Okay, welcome. We're going to be covering chapter 12 today. This chapter can be a little bit difficult for students sometimes to go through, um, in part because, of course, it's very horrific, and we'll be dealing with some concepts that, such as rape and sexual assault. We'll be using some terminology that some people find offensive, but this is a class on the criminal law, so you should be aware of what we're talking about, and before I delve into it, and just kind of be prepared here. So, I when I usually would teach this course, this would be spread out a good deal because I think um, lumping all these things together is uh, somewhat a choice, not one I would necessarily make. Okay, so let's jump in. We've got our learning objectives here, and again, our learning objectives are things you can look at, but are not necessarily critical that you've read them all. These are just the major points that this chapter is trying to accomplish. These things will typically show up on quizzes or tests, so they're helpful to know, but and I don't go over them because they're not absolutely vital. Okay, so the first thing to talk about, your book says, is sexual relations in the United States today. And we're using the term relation because in a little bit we're going to go in and look at different definitions of sexual contact and conduct. Um, so, sexual relations, excuse me, sexual relations becomes a crime in the United States if, first of all, if there's a lack of consent. So, assuming we have two consenting adults, it's not going to generally be a crime, although there's going to be some exceptions. But as soon as one of the adults, either the man or the woman, uh, does not consent to the sexual contact, it will become a rape or sexual offense, or sometimes called sexual assault or sexual activity. It also can be a crime if it's with a minor. Now, typically, the age of consent um, is 16 at a minimum. In some cases, it's going to be 18, and in some cases, when we start to deal with the next category, which is those that have a mental deficiency, uh, they cannot consent. And that mental deficiency could be a permanent condition, um, or it could be a temporary condition, such as being unconscious. If an act is performed in public, it can be a criminal act, a sexual act in public. If a sexual act is performed for profit, in the sense of prostitution, it can be a criminal act. Or there's certain work situations. Your book here singles out therapist to patient, but North Carolina and others will single out things like relationship between a teacher and a student, or someone that's in a custodial situation, so someone like a police officer holding someone, or a jailer. All those can be criminal acts. Okay, now we're going to talk about rape, and then we're going to talk about what your text calls sexual assaults, what tends to be called sexual offense in North Carolina. So historically, common law rape was non-consensual carnal knowledge by force or threat of force. So again, if we go back in time, um, of course, you would go back to a situation in the Middle Ages where women had very few, if any, rights, and that in many ways, this comes as a shock to students, both in the Middle Ages and before. Rape was seen less as a crime against the woman who was raped, because most of these cases are women being raped, than as an offense against the husband or the father of the woman raped. So it was very often that the family's honor was seen as being insulted, and there was punishment, and sometimes it was seen as a legitimate tactic to rape. There's the famous case of in Roman history, the rape of the Sabine women, where the Romans invited a bunch of women to a party and then kidnapped them and forced them into marriage, raped them. And it turned out to be a good thing for the Romans and the Sabines, although, arguably not so much for the women. Um, Today, rape is seen much more as an individual crime, and in many states, we can look at oral, vaginal, anal, penises, fingers, tongues, foreign objects, all as part of the definition of rape. Now, North Carolina doesn't do that, and we'll get to that in a second. Many states, and that's going to include North Carolina, keep rape and then have another charge. So in North Carolina, we have the sexual offense charges. We also do, in North Carolina, like other states, have this aggravating circumstances, things that make rape worse, like first-degree rape or second-degree forcible rape. Okay, so let me jump into North Carolina here. North Carolina has a very narrow definition of rape. North Carolina requires vaginal intercourse, penetration of the female sexual organ by the male sexual organ. And by this we mean the vagina has to be penetrated by the penis. Now the penetration can be the merest contact. It can be just the testimony of the woman, because again, I'm going to use the example of women being raped here. It is a gender neutral, as that second point says, crime. So in theory, a woman can rape a man. Those crimes are pretty rare. So you've got to have a man and a woman involved. If you have two men, two women, or if you don't have vaginal intercourse being a part of it, it's not going to be rape in North Carolina. It's going to be a sexual offense, although the penalties are identical. So let's look at the major North Carolina rape charges, and these are going to be copied in many ways by the major sexual offenses. So we have first-degree forcible rape, second-degree forcible rape, first-degree statutory rape by an adult it should be, statutory rape of a 13, 14, or 15-year-old by someone who's 6 years older, and then statutory rape of a 13, 14, or 15-year-old by someone who is more than 4 but less than 6 years older. Now those are placed in there because occasionally I get questions, and I'm going to jump ahead and just address both of those. What do you do if you have a 13-year-old having sex with a 14-year-old? They're both under the age of consent. Well, we don't charge statutory rape in those cases. But if you had a 13-year-old having sex with a 17-year-old, so there's 4 years, we deem that different than a 13-year-old having sex with a 30-year-old. That would be a higher penalty. Okay, sex crimes is a very broad category. It includes offenses all the way from nuisance to private offenses between consenting adults. We also look at non-consensual sex. This is always going to be a crime. So again, these can be statutory rape. So we've got, and we're going to look at some of these in North Carolina, incest, sexual harassment, prostitution, voyeurism, exhibitionism, child pornography. All of those revolve around sex, the depiction of sex, nudity. All of those can be sex crimes. So North Carolina has a general term called sexual offense. Remember I said rape is reserved in North Carolina for vaginal intercourse. So sexual offense covers everything else, and the big four things it's going to cover are cunnilingus, analingus, fellatio, and anal intercourse. These are kind of self-explanatory terms, but basically they're usually either oral contact with sexual organs, cunnilingus, fellatio, or oral contact with an anus, where excrement is excreted, or contact with an anus by an object or by a penis. That would be anal intercourse. So those are the big things that are covered under sexual offense. Now the penalties are identical. So if we look at North Carolina sexual offenses, you'll see that they parrot the language of the rape, and they're identical in penalty. So we've just decided we're going to set the sexual offenses off to the side. We're going to keep rape by themselves in North Carolina, but the penalties are the same. Same number of years in jail, same statute, same everything. Okay, what are the elements of rape? So again, in the past, there were things like, did the victim resist to the utmost of her ability? And again, I'm going to use the example of a woman being raped here. But a lot of that's been abandoned. In fact, if you feel that resistance would endanger your life, or that explicit resistance would endanger your life, sometimes we'll say no. We're not going to require it. And then there were exemptions when I first started practicing law in North Carolina. There was a husband-wife exemption. A husband could not be charged with raping his wife. In the past, there was a requirement for corroboration. Sometimes in certain jurisdictions, now not North Carolina, but there was a requirement of medical corroboration. There was in some societies, again, not North Carolina, not currently, a requirement of virginity, or that the woman was chaste. So a lot of these have been relaxed. And, one of the big things that's changed is the rise of rape shield laws, where in the past, one of the reasons I think rape victims did not come forward is that their conduct would be described in open court. And since people wrongly, in a very sick way, place the blame for rape on the women who were raped sometimes, they would have this whole experience lived over again, this whole experience brought back out. So they simply said, after rape shield laws, no. And we'll talk about that as it applies in North Carolina, the specific ones. So what are the elements of rape in North Carolina? You have vaginal intercourse with the person by force, and it's against their will. Now, to make it first degree in North Carolina, you would use or display a dangerous or deadly weapon, or something that appeared to be one, or you inflict serious personal injury on the victim, or you inflict serious personal injury on another. So if I was raping a woman and I threatened to stab her child, that would be first degree rape. Or if I'm aided and abetted by more than one person, and this brings up, the case where a man is raping a woman and another woman assists in that. They stand lookout, or they helped lure that person there. We have the Jeffrey Epstein debacle going on, where Jeffrey Epstein killed himself. He's accused of some statutory rape charges and rape, but another woman procured, or is charged with procuring some of these women, luring them in. Well, if you aid and abet in the commission of a rape, you can be charged with rape yourself, even if you're not the one that committed the physical act. Okay, evidence. Now, these just kind of go to some points in North Carolina. The testimony of the victim by herself is sufficient to establish intercourse occurred. Yes, we do rape kits. Yes, we do all sorts of things to prove there was an assault. There's a rape kit, there's a vaginal swab, there's photographs. But, if this occurred in the past, the testimony of the witness, without physical evidence to corroborate it, is sufficient to establish, if the jury believes her, or the judge, that the rape occurred. It is not necessary in North Carolina to show evidence of resistance to physical force. You don't have to be stabbed, beaten, bruised, shot. You can consent for fear that the person is going to kill you, and that consent is not valid. And that person that then goes ahead and rapes you can be charged with a crime. Also, as I said, and this is kind of a throwback to the bad old days of the patriarchy, virginity is not an element of rape. Okay, consent can be an issue. So when can you have consent? Well, obviously, forced or coerced consent is not consent. If I take a gun and I put it to your head and I say, give me what I want and you give me what I want, you didn't consent to that. Yes, you did it, but you did it under the threat of force. If the victim expresses a lack of consent, or if the victim is too young, or if they can't give consent. Now all of these below are somewhat separate issues, and they can be separate crimes. But for example, youth, under a certain age, you can't consent to sex. Are you unconscious? You can't consent to sex. And even if you had consented before you became unconscious, once you're unconscious, you can't consent to sex. So if I drugged a girl at a bar, gave her a roofie, and then before getting her back to my apartment as she was passing out, she said, yes, I want to have sex, and then she passes out, I still can't have sex with her. I mean, it was gonna be a rape anyway, but the fact that she consented to it and then passed out doesn't mean I could go forward and have sex. The absence of consent is frequently raised. All you need to do is show by voice or action at any time that you don't consent. As soon as someone uses force to accomplish it, there is no consent. Threat of force is sufficient. Now, an honest mistake about the victim's consent can be a defense, but not for incest or statutory rape. You can construct rather bizarre scenarios that an individual committing a rape might believe that the person they're raping consents. But these are the rare exceptions to the rules. So yes, it can be raised. No, it's not usually successful. And in most cases, it's pretty ridiculous. Okay, let's talk about rape shield laws, and I'm going to bring up North Carolina's in a little bit. But again, here's the problem. An individual goes through this traumatic event in which she is violated, her personhood is assaulted, and now she has to talk not only about that instance, which is bad enough, but her entire past sexual history is now up for examination. Would you want to talk about your sex life in front of your mother, your grandmother, your father, your grandfather, your uncle, your priest, your rabbi, your minister, the public paper? So most rape shield laws limit past sexual behavior of the victim and reputation, because reputation in particular, should you be able to say, well, she's got a reputation as an easy girl, or as some derogatory term? And the answer there is no, because reputation is proved by instance. Someone may have a reputation as something, and that reputation may not be true at all. It might just be something that is assumed but never proved. So we do allow some information in particular if there is past sexual relations between the victim and the defendant and it goes to consent. For example, we have a rape. Abel rapes Baker. But in the past, Abel and Baker had had sex a lot, or previously. Well, this time Baker says there is a rape. You would be able to admit that yes, in the past they did have sexual relations. Evidence of sex with another person, but only to prove the defendant was not the source of semen. So again, we have a rape occurs. Baker is raped. They do a rape kit, and there's a presence of semen. You could admit evidence to show that Baker had had sex with Charlie prior to the rape kit being gathered. Also, and this is true in North Carolina, did the past victim make false accusations of rape? So someone is raped or claims they're raped. and they have a history of false accusations. All of those would be reasons to pierce the rape shield law. Now, North Carolina rape shield law is found in our rules of evidence, and you can see that in North Carolina General Statute 8C, Rule 412. Basically, it bans any sex act other than the one involved in the charge, except for previous contact or that they didn't commit it. So North Carolina is not going to let the opposing attorney, the defense attorney, really go in and attack the rape victim here. They can bring up facts, they can bring up what occurred, but Rape Shield really protects her. All right, statutory rape. Now, different states are going to have different ages of consent. Also, we obviously tend to think of rape getting worse as the child gets younger. And we also think of rape as worse as the perpetrator gets older. So the general rule is it is not a defense, okay, that you have sex with someone and they are underage and you didn't know. It is when you have sex with someone, it is your business to find out their actual age. And if you don't know their actual age and you have sex with them, you're rolling the dice. Because if they're under 16 in North Carolina, it's a statutory rape charge. Period. End story. Now again, other states make it more serious, or less serious, or set out what I call the age delta. So what North Carolina does is the offender at age 18, you'll notice there's a 4 or 6 year spread, and the victim is under 13 are two important points. Once you're over 18, it's going to be the most serious statutory rape charge. But lesser charges exist if there's only a 4 or 6 year delta, and that should be ages 13, 14, 15, not 12. Age of consent is 16 in North Carolina unless you are a substitute parent. So you might have a 17-year-old, you're living in a house with them, you're acting in the position of a parent in North Carolina, you have sex with them, bang, it is a statutory rape charge. Any activity by someone with their student or someone in custody is illegal. It is a rape or a sexual offense, sexual assault, for broadly for both of those. Okay, incest. This is a dark secret. It's estimated that somewhere between 60 and 100,000 female children annually are sexually abused, and that 80% of this is not reported. It's also believed that 10% of American families, and this is a frightening number, there is some instances of incest. And again, incest runs the gauntlet from intercourse to molestation to oral contact, just inappropriate contact. It could be exposure or voyeurism. It could be lots of things. So there's at least 5,000 cases of father-daughter incest yearly in the United States. It can be committed by any adult in a family, any family member, but generally we look at children being involved. It is technically still going to be illegal for a 50-year-old father to have sex with a 25-year-old daughter or son. Now, like statutory rape, incest does not require force, and consent does not matter. Although in most states, including North Carolina, you do have to prove the actual relation exists, and you have to prove that people are aware of it. So what are North Carolina's charges here, these general ones, and this is more than just the incest charge. We have a crime against nature charge, which is a very old statute. It's 14177. We have an incest charge, 14178. We have a bigamy charge. That's where you seek to have more than one spouse, and that is a gender-neutral charge. It can be either polygamy, more than one wife, or polyandry, which is more than one husband. We still have the old fornication and adultery, although it's questionable whether it's constitutional. We have an indecent exposure statute, and we have a peeping statute. Okay, so crime against nature in North Carolina is still on the books, and it's a very weird statute in many ways. And I say it's a weird statute because you would think that it's been eliminated. I say you'd think it's going to be eliminated because in the past, crime against nature was primarily used as a charge against people engaging in gay sex. And as in the 1980s, I can recall practicing law in Raleigh, instances where individuals, there was one case I was in Wake County, where someone was being charged with burglary, and his defense was he couldn't commit burglary because they were having sex at the time. And crime against nature was so broad, it covered everything. It covered everything but vaginal intercourse. So even though he was having, in this case, he was having oral sex with his girlfriend, he was acquitted of the burglary because he had that defense. But since he admitted to crime against nature, he was convicted of a felony. Now, this was impacted by a case called Lawrence v. Texas. Lawrence v. Texas, which came down in 2003 in the United States. There was a very similar statute to North Carolina's crime against nature statute. North Carolina's crime against nature statute, believe me, is the whole thing is a person's guilty of this offense if they, one, here are the elements, ready? You commit a crime against nature. That's it. And that was defined by case law. So in Lawrence v. Texas, Texas had a very similar statute. It was used to prosecute homosexuals. It went up to Supreme Court. It was struck down. And the question was, well, is this still constitutional in North Carolina then? And we need this statute, or think we need this statute, because of a weird quirk with our prostitution laws. Prostitution in North Carolina only covers vaginal intercourse. So a prostitute, in theory, could raise the defense of, no, I didn't give him oral sex. I didn't give him vaginal intercourse. I gave him oral sex. It wouldn't fall under our definition of prostitution. Therefore, would it be legal? No, because North Carolina's retained crime against nature, you would be avoiding a misdemeanor charge of prostitution by admitting to a felony charge. And this seems very much in the weeds here, but let me just leave it with this. Crime against nature continues to exist. We use it for certain coercive acts and acts of prostitution anymore. That's it. Incest in North Carolina. Now, North Carolina still has an incest charge. We have incest with a child under 13. We also have the 13, 14, 15, where you're 6 years older than the victim, or 13, 14, 15, and you're more than 6 years older than the victim. So we've got all of those. Fornication and adultery is one of those weird things still hanging around a little bit, probably is unconstitutional. Basically, the statute in North Carolina says, if any man or woman not being married to each other shall lewdly and lasciviously associate, bed, and cohabit together, they shall be guilty of a Class 2 misdemeanor. I've seen this used, fornication, adultery, and cohabitation, to discharge people from jobs. Because if you commit a criminal act, it's often a violation of a moral charge. So is this still around? If not this, certainly occupying a motel room for moral purposes, which I think is North Carolina General Statute 14186, is still around. So yeah, it's very questionable. Okay, HIV. this is a strange place to put this, but your book decided to put it in there. During the AIDS epidemic of the 80s and 90s, there was fear of the spread, and this led to specific acts. In all states, knowingly, recklessly, or negligently exposing or infecting another person to AIDS is a felony. Do we have sex registration laws? Yes, we do in North Carolina. Most states, including North Carolina, have something like what's called Megan's Law. If you are convicted of, and North Carolina has a long and exhaustive list of sex crimes, if you're convicted of one of those sex crimes, you have to register when you're released from prison. If you're not in prison, you've got to be on this list. You got to tell the sheriff of the county you're resident in where you are. You go into a database that's searchable. You can find these online. Initially, only the worst were. Now, pretty much everybody who's on it. They also prohibit certain things. So North Carolina has a lot of laws. We limit access. By the way, North Carolina also retains an alienation of affection, and it's more civil than criminal, but I thought I'd throw this in there because I was researching for this chapter, and I found that there was a $750,000 award by a husband against a person who had an affair with his wife, suing under alienation of affection. So there are civil laws that, interestingly enough, impact this. Civil commitments, not something I want to spend a lot of time on, but in some states you can get a civil commitment order where you've got someone who's dangerous, they're getting out of prison, but we're going to hold on to them. Washington State, interestingly enough, is somewhat notorious for this. Okay, prostitution. Prostitution in North Carolina, as I said, has kind of a weird history. First of all, prostitution is a misdemeanor in North Carolina. It's a Class 1 misdemeanor. So the statute here is 14203, as I recall. And it makes it an offense to engage in prostitution or what we call assignation. So what's prostitution? Having sexual relations with another person for a fee or something of value, offering to do that, or actually agreeing to do that. We also have pandering, which is inducing someone else to become a prostitute or maintaining a place. North Carolina has specific ones. And then we have specific ones as well for minors engaging in prostitution. So North Carolina has engaging or procuring for prostitution. That's our big statute. The engaging one is 203, and then I think procuring is 204, if I'm not mistaken. So you'll hear the language in there of prostitution, which is, if we take the classical example here, a woman who sells the agreement to perform a sexual act, or assignation, the man who buys it. Both of those are crimes. And then we have multiple offenses if there's minors involved. So we have things like facilitating a minor's prostitution, supporting, supervising, or protecting a minor's prostitution, or participating in a minor's prostitution. All of those have fairly strict penalties. You can get hit pretty hard. Even if you, let's suppose you have a minor a child that is a minor, and you let someone have sex with them, that's going to be, well, if you force them, of course, it's Class C felony in North Carolina, which is a lot of time in prison. But if you knowingly supervise or support or advise or protects the prostitution of another, of a minor, it's a Class C felony. And remember, Class C felonies carry a lot of time in prisons. And then participating, actually sleeping with a prostitute, is actually a Class F. With a minor in an act of prostitution is Class F. Now, of course, there are some things that we begin to really cross the line where people say, well, is this sex or is it something else? So you generally will hear the term lewd or lascivious. Um, it's a common term. It's some sort of sexual contact without penetration. Very often it's touching someone's private parts. So if I came up and grabbed a woman's breasts, or if I grabbed a man's penis, that would be lewd lascivious behavior. It obviously wouldn't fit under the big category of sexual offenses. It's not cunnilingus, analingus, fellatio. It's not vaginal intercourse, but it's still going to be a criminal act. We also have specific statutes in North Carolina and in all states about pornography. Now, adult pornography, I would say the battle's largely been lost thanks to the internet, but child pornography still carries very stringent penalties. Child pornography doesn't even need to be obscene. A dissemination of something that is claimed to be obscene is enough there. It doesn't matter if it is there's lots of things that make a child pornography. It is the one area I think that you see near constant and vigilant prosecution of pornography. To possess it, to produce it, to sell it, to solicit it, all are crimes. And there's some interesting things that we can talk about in class about this that I will mention, but I like to keep these lectures fairly short. Now, because of the internet, one of the things that has gone on is people who are interested in child pornography have been able to establish ways to not only just sell this, which is horrific, but also to share it. And sometimes they're sharing images which would not necessarily be pornographic to you or I, but would be sexually enticing to them. So an example would be, let's suppose you take a picture of a naked baby on a bearskin rug, the kind of classic. People might have that in their photo albums. People might have things like that, and they might not think, well, that's not pornographic. But a pedophile might be sharing images like that with comments on them or with modifications online, and it would be child pornography. So North Carolina has obscenity laws as well. We have a disseminating obscenity statute. So let's talk a little bit about obscenity. And again, we are looking at something that's got, really needs a definition as to what is obscene. And the first thing I can tell you is that the only obscenities that are recognized are sexual obscenities. So acts of violence are not obscene in North Carolina. So North Carolina's disseminating obscenity statute, which is 14190.1, makes it a criminal act to intentionally disseminate an obscenity. All right, so I'm hoping that at this point you're saying, okay, well, what's an obscenity? The definition is material that describes or depicts sexual conduct in a patently offensive way. Sometimes we say it appeals to your purulent interest. We do look at really three factors here. Let's say four factors. One, does it involve sex? Two, does it offend the average person? Three, does it lack any literary, artistic, political, or scientific value? Or four, does it have any protections under law? We also have North Carolina sexual exploitation of a minor, and we heavily regulate adult establishments, what can be in them and what can't be in them. One of the questions I get is, can someone who is paying 2 stars to engage in sex, porn stars to engage in sex, can they be charged with prostitution? We have the case of California versus Freeman, where Freeman was convicted of hiring adults to perform sex, which you might say, well, it sounds like intercourse for hire to me, it sounds like prostitution of some types, and then selling the videos. The Supreme Court said if this is filmed in a private place, no, it's not procuring for prostitution. We also have lots of statutes on voyeurism, peeping toms, North Carolina specific ones, peeping into a room occupied by a female, for example. And we have statutes of indecent exposure. There's been a number of attempts to upgrade these laws with limited effect. Okay, that's about 40 minutes. That's all I wanted to cover. Hope the lecture was edifying for you.